Good afternoon, everybody. My name is Sagarika Sahoo, and I'm a practicing advocate at Odisha High Court, Cuttack. And today I'm going to speak on the topic Reformative Justice, as requested by D. Lex Doctorum, who are a group of young law students who aim to propagate legal awareness. Now, according to Roman jurisprudence, punishment should not be for the sake of punishment, rather, it should be for reform. So, after the retributive, deterrent, and preventive theories of punishment failed to reduce crime in the society, there came the need for reformation, a reformative theory of punishment. And the most distinct feature of this theory is that, unlike others, it is focused on the criminal rather than the crime. The most important aspect of this theory is to bring about a change in the nature of the offender and to rehabilitate him back to the society. According to this theory, people commit crimes because of psychological reasons, because of societal reasons, because of environmental reasons, and hence the criminal is not treated as a criminal but rather as a patient. This theory also postulates that while awarding punishment, the concerned judge should study the character, age, and the circumstances under which the offender has committed the crime and should accordingly sentence him. This theory is also strictly against death penalty because believers of this theory say that hanging a criminal merely is an admission that we as human beings, we as a society have failed. Having said so, let us now come to the Indian context of punishments. Now, under section 53 of the Indian Penal Code, we have different sets of punishments which the court may award to different criminals, which are death penalty, imprisonment for life, imprisonment which may be either of description rigorous or simple, forfeiture of property, fine. Now, India largely follows a reformatory and a restorative approach towards offenders, and at the same time, there is some amount of deterrence in the system. Now, I will take the viewers to the different legislations which are present or prevalent in the Indian legal system, which have the essence of reformation and rehabilitation in them. Now, the oldest legislation on reformation is the Reformatory Schools Act 1890, which aimed at preventing depraved and delinquent children from becoming confirmed and hardened criminals in the coming years. Now, this act applied to children who are under the age of 15 years, and the courts were given the power to direct these youthful offenders to reformatory homes or schools instead of jails or prisons for a period of 3 to maximum 7 years instead of imprisonment. Thereafter, the Children's Act 1960 came into the picture, which provided for the care, protection, maintenance, reformation and rehabilitation of neglected or delinquent children who are in need of such reformation, and for the trial of such children in delinquent courts instead of regular courts. Now, this act strictly prohibited the imposition of death penalty or sentence of imprisonment or use of jails or police station for keeping children under any circumstances. This act was finally replaced by the Juvenile Justice Act in the year 1986, and which I will deal with later in the video. Now, another major legislative example is the Probation of Offenders Act 1958, which was enacted to provide for the release of offenders on probation or after due admonition. Now, let me first say what is the meaning of probation. Probation is a non-custodial alternative that is used by the magistrate where guilt is established but it is considered that imposing of prison sentence would do no good to the offender. So this act provides for probation instead of imprisonment for those who are guilty of offences not punishable with death or life imprisonment on probation of good conduct, having regard to the nature, circumstance, and character of the offender. Now, this act also has resonance with section 360 of the Criminal Procedure Code 1973, which empowers the court to order the release on probation of good conduct or after due admonition. Now, there are certain preconditions to release a person on probation, which are: there is no previous conviction proved against the offender. Second, when the person convicted is a woman of any age or any male person under 21 years of age, and the offense of which he or she is committed or convicted is not punishable with death or imprisonment for life. Third, when the person convicted is not under 21 years of age and the offense with which he is convicted is punishable with fine only or imprisonment for a term of 7 years or less. So in these cases, the court under section 360 has the power to release the offenders on probation or after due admonition. Now, in the state of Odisha, we also have certain provisions which relate to grant of parole and furlough. So in Odisha, we have the Prisoners Release on Furlough Rules 1963, which grants furlough to a prisoner who is sentenced to less than 5 years of imprisonment, and the maximum time for which a prisoner may be granted furlough is 3 to 5 weeks in 1 year total. We also have the Odisha Release of Prisoners on Parole Rules 1983, which defines the purposes for which the parole shall be sanctioned, which are serious illness or death in the family, or marriage in the family, or construction or repair of dwelling house if there is no one else to look after it. And the period of leave is maximum 30 days, and the rules are almost the same as furlough. So what I'm trying to say is that both parole, furlough, and probation are reformation oriented approaches and have been shown to be of great use to convicts by enabling them to maintain meaningful contact with the families. However, there are certain cases in which parole and furlough may be rejected. For example, in cases where the offender is a repeated offender, or where they are convicted offenses like rape or murder, dacoity, etc. Now, the next provision or the next law that I am going to discuss with you is the concept of plea bargaining, which is present in section 265A to L of the Criminal Procedure Code. Now, plea bargaining means bargaining for a lesser sentence, and it is not a complete alternative to imprisonment, but it is a start towards establishing a more reformative system of punishment. First of all, this concept of plea bargaining is only applicable to cases which carry imprisonment of less than 7 years and is not applicable to cases against women and children. Next, we have the provisions of fines and compensation given in the Indian Penal Code. So most of the offences have the punishment of fines or imprisonment or both. So the courts have the power to impose fines only instead of imprisoning the offender, provided the facts and the circumstances of the case allow so. Now, next we have the reformative justice in juvenile justice laws. Now, juvenile justice in India is largely regulated or governed by the Juvenile Justice Care and Protection of Children's Act. And this act makes special provisions for development, rehabilitation of delinquent offenders under 18 years of age. And this act is based on two fundamental assumptions. First, Young offenders should not be tried but should be corrected. Second, they should not be punished but treated. Other than the Juvenile Justice Act, the Indian Penal Code under Section 82 and Section 83 also extends total immunity up to the age of 7 years, extending to 12 years. Now, other than the legal systems in the country, of which that I have already discussed, we have the concept of panchayats, the concept of customary laws, which tend to adopt a more reformatory approach. For example, there are many tribes in India which consider the entire community responsible for an offense rather than stigmatizing a particular individual. Right. Other than that, there are provisions regarding compounding of offences under the Criminal Procedure Code, which are given in Section 320 of the Indian Penal Code, 320 of the CRPC, and this provides for settlement of dispute between the victim and the offender, and it has been one of the most recognized mechanisms to attain reformative and restorative justice in the Indian legal system. Now, having discussed these laws where reformative justice is prevalent, it is important now to scrutinize if reformative justice is actually fruitful in the Indian context in comparison to retributive and deterrent theories of punishment. First of all, reformative theory expects better facilities and infrastructure in prison, proper coordination between different discipline and persistent effort and approach on their part to mold the criminal. And it requires huge investments which probably a country like India cannot afford right now. Second, the rationality of the theory is more towards incentives for the commission of crime rather than the prevention. And this theory does nothing for the victims of the crime and is a convict-centric system. And in a country like India, where the crime rate is already so high, it is not possible to fulfill the goals of reformation to the fullest. Next, reformation can work only on those people who want to be reformed. And those people who cannot be reformed, like hardcore criminals, educated people, and professional criminals, probably the concept of reformation may not work on them. And which is why this theory has failed at times when, in spite of being rehabilitated to the society, offenders continue committing more offenses and end up being habitual offenders. And a large aspect of this is because the society in the first place does not accept the criminals even after they have been rehabilitated. So these criminals end up becoming habitual offenders and the entire concept of reformation fails then. Next, in matters of murder, gang rape or severe assault, the theory of reformation may serve as a barrier in serving justice to the victims of the crime. And in cases of heinous crimes and hardened criminals, it is seen that reformation and rehabilitation of prisoners does not help. Moreover, many scholars have suggested that it is hard to digest that corrupt social environment is responsible for the crime rather than the individual himself. And in a country like India, which does not have the proper resources to implement laws regarding parole, probation, and other rehabilitative measures, it may be difficult to extract the entire fruit of this theory. Moreover, lastly, reformative theory deviates from preventive measures, and there is less focus on the prevention of the crimes and sensitization of people than it should be. So, if I have to conclude my lecture, I will say that it is a fact that the prevention of crime and protection of society are the main objects of the society. And no single theory of punishment will probably serve the real purpose wholly. And even though prisons were made to correct offenders, they have now become redundant. So, in my opinion, the criteria for the sentencing of punishments should be altered in a way that it not only reforms the offender but also creates a sense of fear in that offender towards repetition of such crime. Thank you.